In a 2003 affirmative action case, Justice Sandra Day O'Connor proclaimed that the court expects that 25 years from now, the use of racial preferences will no longer be necessary. And in a 2007 case overturning a school integration program, Chief Justice John Roberts argued that the way to stop discrimination on the basis of race is to stop discriminating on the basis of race. These two statements, one in the case of affirmative action and one in the case of school desegregation, raise important, potentially diametrically opposed questions. In one, the use of race is seen as legitimate, though temporary, but in the other, the use of race is seen as illegitimate. To make sense of school desegregation and affirmative action cases, though, it's important for us to frame them in light of race in American political development more generally. It is only since the 1950s that we have seen any fundamental progress in race relations in the United States. Since then, we have arguably made tremendous progress. We have passed civil rights acts, voting rights acts, overturned school segregation, and elected our first African-American president. But it wasn't always so. We can't forget that the Constitution originally sanctioned slavery. Though it never specifically mentioned the term, the institution was protected most conspicuously in the Three-Fifths Compromise and the Fugitive Slave Clause. Of course, the Civil War brought emancipation and the 13th, 14th, and 15th Amendments, which obliterated the formal institution of slavery and, at least on paper, guaranteed some fundamental legal and political rights for African Americans. But we also know that these gains were soon lost after Reconstruction, as Jim Crow and its attendant laws that legalized discrimination reared its ugly head beginning in the 1880s. The court in Plessy v. Ferguson in 1896 formally gave Jim Crow its stamp of approval with its affirmation of the doctrine of separate but equal. Over the next 50 years, many fought to undo this doctrine, finally achieving success and overturning it in Brown v. Board of Education in 1954. The next two sections of the course take up cases and controversies that have arisen in the wake of these relative successes. In the case of school desegregation, we see the court slowly dismantle the formal and informal laws of segregation in public education in the United States. In Brown v. Board of Education in 1954, the court effectively overturns its ruling in Plessy that separate but equal is constitutional. In subsequent school cases, though, the court initially extends and upholds this ruling, but starting in 2007, it begins to place limits on plans that use a numerical quota in order to achieve desegregated schools. In affirmative action, we see the court and the country as a whole debate the merits of race-conscious public policy. How can we take race into account in the areas of college admissions, employment, and the awarding of government contracts if we believe that race shouldn't matter? Although the court will uphold the use of affirmative action as a means to achieve diversity in the cases that you'll read, it's still suspect of affirmative action policies in general, especially those that would set quotas. In fact, some on the court would like to see affirmative action ended completely, especially the court's second black justice, Clarence Thomas. In school desegregation, then, we see the advancement of a colorblind theory of constitutional interpretation. Policies that differentiate between people based on race are inherently suspect and almost always unconstitutional. But in the affirmative action cases, distinctions based on race are upheld. In other words, it might be the case that in order to end racial discrimination in all of its forms and achieve a colorblind constitution, we must first take race into account to undo past discrimination, or as the court has argued, to foster the necessary level of diversity to achieve those ends. We have made tremendous progress in race relations in the United States over the last 50 years, but there still remains work to be done. So as you read these cases this week, consider the following. Is there really a paradox in our race cases? Is it really a choice between taking race into account or having a colorblind approach to constitutional law? Considering our less than stellar history of racial discrimination in the United States, how do we make sure that democratic majorities do not discriminate based on race? Is affirmative action the answer? If it is, how do we know, if at all, when we've achieved the right balance? Is there even a correct balance in schools and employment? Should race-conscious policies be viewed as temporary or permanent parts of our constitutional system? Should we limit these policies solely to African Americans, considering our history, or should these policies be extended to other minorities? There are no easy answers to these questions, and the court is still working them out. Nevertheless, it's safe to say that issues of race will continue to challenge the court and the country and the Constitution for years to come.